ওকে স্যার জয়েন করেছেন। জয়েন করেছেন একটু দেখে নাও। দিদি আমার বলার শেষ হলেই আপনি দেখছেন বললাম আমার বলাটা শেষ হলেই আপনি ধরে নেবেন। হ্যাঁ হ্যাঁ আমি শুরু করছি তারপরেই আপনি বলবেন। স্যার জয়েন করেছেন মেসেজ করেছেন। আমরা শুরু করে দিই তাহলে। স্যার কি স্যারের ভিডিওটা কি অন আছে? এই তো স্যার এসে।
হ্যাঁ স্যার এসে গেছেন। থ্যাংক ইউ স্যার। থ্যাংক ইউ স্যার এসে গেছেন। স্যার আমরা শুরু করি।
নমস্কার নমস্কার নমস্কার।
হ্যাঁ তাহলে আমরা শুরু করি স্যার আপনার প্রেজেন্টেশন। সমগ্র
ওকে স্যার।
সমগ্র কোথায়?
হ্যাঁ স্যার ওকে স্টার্ট করা যাবে।
স্টার্ট করব?
হ্যাঁ 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 ওকে স্টার্ট।
Should I start? Good afternoon, ladies and gentlemen. Welcome to the two-day international webinar on intellectual property rights and research publication, organized by IQAP of Sarojini Naidu College for Women. As you know, we have divided our webinar into two parts. On day one, we would actually concentrate on the various nuances of intellectual property rights and look at its various aspects. And on the second day, we particularly focus on research publications. Now, in this COVID world, when the scientific community is deeply interested in search for a magic bullet, a magic vaccine maybe, the issue of intellectual property rights becomes much more significant. Now, historically, if we trace the concept of any such right, it can probably be traced back to the post-Renaissance Europe. However, I find its roots from the very early days of man, because probably we have a reference to it in the very biblical story of the fall of man. Now, in this story, we find that the figure of God is trying to fiercely protecting his research, and the product of his research is nothing but the mythical fruit of knowledge. And Satan successfully ensnares Adam and Eve to steal it. Now, if we fast forward to the present era, and if we replace the figure of God with that of a superpower nation, or for example an MNC, if we replace Satan with another MNC or another superpower, and for example we can replace Adam and Eve with a scientist involved in espionage, and finally if we replace the apple with some nuclear research or a heavily guarded trade secret, we have all the masala of a James Bond spy thriller. However, over the next 2 days, we are going to concentrate upon the real issues rather than on any mythical interpretation. Today, we'll be enlightened on IPR by Dr. Sandeep Choudhury, a veteran in the field, and a young aspiring scholar, Dr. Kaveri Dotto. Dr. Choudhury is ex-Chief Scientific Officer, IPR and IR of IIT Kharagpur, and Dr. Dotto is Assistant Professor of the Department of Zoology in our college. we're delighted to have both of them in our midst. We also have among us our principal, Dr. Urmila Ukil, who has always been a source of inspiration for us and supports us in all our endeavors. Madam, I welcome you to this virtual platform.
Thank you.
And we are really elated to find that Professor Bashab Chaudhuri, the Honorable Vice Chancellor of West Bengal State University, has kindly agreed to grace the occasion. Professor Chaudhuri is practically a guardian of our college, and he needs no formal introduction. His academic works, his brilliant eloquence, his administrative acumen all speak for themselves. But most of us revere him for his human spirit, philosophical bent of mind. Sir, may I extend a very warm welcome to you on behalf of the entire Sarojini Naidu College family. I now invite Dr. Urmila Ukil, our principal, to kindly deliver the welcome address. Madam, the stage is yours.
Thank you, Jyoti.
Thank you.
My dear colleagues, guests, and participants, a very good afternoon to all of you. On behalf of Sarojini Naidu women, it is my immense pleasure to come all to the International Seminar on Intellectual Property Rights and Research Publications organized by the IQAC of Sarojini Naidu College for Women. I express my deep gratitude for Honorable Vice Chancellor, Professor Bashab to give his consent to deliver the keynote address. He is always a great source of inspiration to all of us. I express my gratitude to the eminent speakers, and our IPC coordinator, and her team for organizing this webinar. I thank all colleagues and the participants for being present in this webinar. As India and the world at large steps into the era of knowledge economy, the tangible expressions of our intellect is increasingly being regarded as a precious asset and property that through technological advancement, better dissemination of information, and newer avenues of research and development. Consequently, it necessitates that we become aware of the rights, laws, and applications related to such intellectual property, particularly as because propagators or bearers of knowledge ourselves in order to keep pace with the demands of the times. In doing so, each one of us will be able to apply these unique assets of ours towards the prosperity of the individual, the society, and the country in the continuing days. When talking about intellectual property, one of the prevalent ways by which we express our intellectual curiosity is by research activity. The fruits of research are presented to our peers and the public as research publications. Therefore, it stands to reason that with the changing times, the way we do research and present it, it had also undergone extensive transformation. We will be missing out if we do not update ourselves on the modern norms and ways of research publications. this intention, we have organized this webinar spread over 2 days so that all of you may become well versed in the subject of intellectual property rights and research publications. We have on board accomplished professors, professionals, academicians who will be speaking to you about these subjects, and I believe that you will all be greatly enriched by the deliberations of our learned speakers. I wish all of you an enjoyable 2 days of the webinar. Thank you all again. Now, I am requesting our Honorable Vice Chancellor to deliver his keynote address. Professor Chaudhary, sir, I am requesting you to deliver your keynote address.
Good afternoon to all of you. Respected Principal of the College, Dr. Urmila Ukil, respected IQSP Coordinator, Dr. Chatterjee, respected anchor who is doing the anchoring today with a lot of enthusiasm and expertise, Dr. Joydeep Rishi, respected teachers of the college who are all on virtual platform. The two respected speakers, one is Dr. Sanjeev Kumar Chaudhary, the other is Kaveri Dotto, who will be enlightening the persons coming over here today on the patent rights and things like that, and all others who have joined on this webinar. On behalf of the West Bengal State University, I would like to thank the college. I would like to congratulate the college for organizing different webinars in succession, one after the other, on subjects of great importance, subjects of great importance. Today, the webinar is on intellectual property rights and research publications. All of you know that when the UGC University Grant Commission of and the time decided that colleges also can achieve any college having two faculty members who are having PhD. The college can start research centers where research can be done by the teachers of the college and by other members if they join as joint supervisor and things like that. Now, at this point in time, I would like to tell you, even in 2010, when I was with the University of Calcutta at the time, a place of research used to be a bone of contention. Research lose as because of research in university departments. In 2010, the colleges were recognized as the basis of research. And today, it has been accepted, and the autonomous colleges, Belur Math Ramakrishna Mission Vidya Mandir, of which I was a student, the Ramakrishna Vivekananda Centenary College, Rohoda, these are the different colleges where research is taking place at that particular place of research. So the research place has changed from university department to colleges, and in this manner there has been democratization. Democratization of research means the teachers in the colleges can do research on their own on different subjects, and the colleges can conduct the research entrance test. The colleges can conduct the different coursework and things like that. And then the experimental work also can be done, the theoretical work can be done, and the colleges can do. But this thesis will be submitted to the university, because it is under the university that the research will be done. Now, publications come out. All of you know that before the patent regime, There is some sound, background sound coming. If the phone is muted, I think that will help. If the microphone is muted, the background sound will not happen. So now, what I was saying is this: that if now what comes out of research is basically some results, some conclusions, and those are usually communicated in the two research papers in different journals. And those journals are having different names. For example, if you talk about review literature or reviews, then the high quality journal. If you talk about lesser quality journal, there are different journals. So you publish, and that is basically open literature. Open literature is basically those where the research publication is published and the research work is documented over there through publications, and that is basically open literature. Vis-a-vis open literature, there is something called patent literature. What is patent literature? Patent literature is basically patent information. Patent information will be those information where the person who is doing the patent or who is having the patent will have some kind of right on that. And if that information given in the patent is someday commercialized, the patent owner will get royalty because it is his discovery or it is her discovery. I hope I am able to make you understand this point. Patent literature is basically that information, that part of information which comes or which gets associated with the right owner of the patent. We have this patent. Thomas Alva Edison, I think, had thousands of patents because he could develop and he could publish, he could discover many things. So he had patents. Now, these information, they are really particular patents, and patents are filed. Indian patent, United States patent, Chinese patent, Japanese patent, and there are different patents. And patents are for different things. For example, if you can have a paper, thermally sensitive paper, on which printer of the computer writes, that thermally sensitive paper is a big thing because if you can prepare it, you can because that's something that is not made in this country. All the things are imported. What if you have right to patent right your work? Possibility that patent will be commercialized someday. If it is commercialized, you get and in the form of royalty. So that is basically the power of the patent. People, in this world started patenting long back, much before we, because think of the industrial revolution. And industrial revolution started in England, and then new materials and new processes were discovered, and there was a necessity to have ownership on those processes. How do you establish this ownership? You establish all these ownership through the Patent Rights 1990. The process patenting, or all over the world, it was the case. Process patenting was available. That means you develop a process for a particular material. That may be an adhesive, that may be a drug, that may be an intermediate, that may be a machine, that may be something different, that may be a paper, that may be a toothpaste, that may be a toothbrush, that may be a special plastic having some what is known as functional polymer, having some special properties. That may be a glass smart material. Smart material means that changes color as you go out in the sun and things like that. Anything that you can talk about, anything. Now, if you have that kind of patent, the process patent, you are saying that A and B were mixed together, and then C was produced, C was separated from a mixture of products, then that C was done this way, and I got this material. So it is basically C. So it was your process. This process cannot be replicated because the process was patented, right? If you do not take A and B, If you start with something different, if you start with P and Q and reach the same product C, no one will say anything because your process is different from the other process. So that was basically process patent. India had a great privilege of doing experiments through process patenting. During the process patent regime, India could somehow sell through without much of a problem. Then came, after the GATS agreement and all those stuff, all of you know, General Agreement on Trade and Services and all those, and that Dunkel agreement, 1984 and things like that. What came was then the globalization and things like that. After 1995 or so, or 2000, it became product patent. What is the meaning of product patent? That I have taken a product and you cannot replicate the product. That means I have been able to develop a drug. I have been able to develop a polymer. I have been able to develop a nanomaterial. I have been able to develop a special protein. I have been able to develop a special drug. And that product is patented. That means that product is mine. That means unless you do a lot of experiments to see right from the beginning, molecular level, that something is really working, you will not be able to you will not be able to manufacture the material, you will not be able to make the material. So it is become product patenting, right? So in product patenting, life has been very, very difficult. And patent is basically something people claim that we have a patent. No use of having patent unless the patent is commercialized. The patent must be used for commercial activity. People will come to you and say that I will have a patent simply because it has wealth of information. I want to make the material. Patent and publication become synonymous if the patent is not utilized properly. I think I am trying to make you clear on this point. See, you have a patent, but that patent is not used by anyone. What do I do with that patent? You have a material. That material does not have any utility value. And that utility value is important today in science and technology. Unless you have that utility value, the patent does not have any solid value. You may have a patent. Many people have patents, but those patents are never commercialized. If they do not fetch money, the patent is not really that useful. One must try to understand that point. So when we talk about patents, we must have useful patents. We must have patents which will be utilized by people to make money. And that is how you get royalty. That is important. What is the meaning of intellectual property? Why intellectual property? Because any information given in patent or wealth of information given in patent, how does it come? How is it produced? It is produced because of research done in the laboratory. It is produced because of the computer work done in the laboratory or in your house. It is produced because of the large amount of computer time and your brain power that has worked, that have gone into it. So now, the amount of information that has been produced, behind that, there is a lot of intellectual exercise. And because you have done that intellectual exercise, you must have that intellectual property under your belt. Otherwise, people may take that away. And by taking patent, you want to ensure that no one takes that patent rights away. I hope I have been able to make it clear to you that intellectual property means property that is basically wealth of information. That information will be in the form of literature. That information will be in the form of published material. And that information is a result of intellectual exercise that you do in the laboratory or in different places of work. It may be a college, it may be a university, it may be anywhere, right? In order to write the patent, you must also know who writes the patent well. Patent lawyers are there. They write patents. There are certain ways. Everyone, Tom, Dick, Harry cannot write patents. Patents have to be described in a very nice way, and they will be examined. You submit the patent, and then those patents will be examined by the patent patent office, and the patent office will finally will ask you some questions. On that basis, you will give clarifications. There are filing charges, and finally the patent rights are given that yes, you have the patents on your name, and this is the patent, and please go ahead and yes, you are. And then you can write in your CV that I have got a patent. Again, curriculum vitae is not the end of the world. You may have patent on your CV, but unless the patent is commercialized, you will not get money out of it. How is the Western world doing? The Western world is making money out of patents, and that is where the prowess and or the strength or the power of patent lies. That I have done a patent, I have sold a patent, and because I have sold a patent, I have, for example, Thomas Alva Edison's first electric bulb. Someone else sold the patent to him. Some English scientist sold the patent in the year 1908 or so. I think I'm not mistaken. If you go to Thomas Alva Edison's work, you will the history of light bulb, you will find out. So the point is, I think it is 1909 he first demonstrated, and then 1912 that electric bulb came. I mean, the one that is that which fetched him money. He had 1,200 or something like patents. He had large number of patents. Large number. Maybe I am underquoting the figure. He had large number of patents. So patents are basically useful only when you can make money out of patents. So intellectual property is the property, and you must have that property. Now, what kind of property do we have? We have land property. We have a flat. We have a house. We have some ornaments. We have some security deposits. We have some fixed deposits. These are all property. If intellectual property is with you, you can sell that intellectual property, and that intellectual property is kept secret in the form of patent. Secret means not entirely secret. You give some sketchy information about the product, and then you say, this is my product. No one can replicate. No one can say. All the big drug companies, they're having patent on molecules, and they do business for 2 years, 1 year, 2 years, and then they go for the new drug. Entire money they get out of that material. Cancer drugs. Today, SARS-CoV-2 drugs. If SARS-CoV-2 drugs are remdesivir or detonavir or whatever material, whatever are going on, they are not exactly the drug that is exactly working on this COVID-19. They are just they're very, very close. It is going around. It is not really hitting the target. So if some company develops this hitting the target drug and can take patent, they will have enormous fortune in 1 year or 2 or so, and then the vaccine or things like that. And that is how the patent will be useful or will become powerful, because it gives a lot of money in the form of a sale of patents, or maybe utilizing the product out of those patents. When you are making the product, you are also doing the patent, because no one else can make that drug. If someone else makes it, the patent infringement will be there. Must be knowing the word infringement. What is the meaning of infringement? Infringement means someone else is entering your house without your permission. So, trespassers are prosecuted. It is written in government properties. So you cannot trespass. You cannot enter into that domain. And that is how the patent information is protected. Again, I am saying patent will be useful if you can sell it. Otherwise, for the sake of doing patents, if you do patents, it is not much useful. It becomes another information in your CV. That's all. I will not take more time. There are already very important speakers who has been in IIT Kharagpur in this area. Sanjeev Chaudhary. There is Kaveri Dotto, I think, who will also speak. So there are persons who are really resource persons. The principal of the college, Dr. Gil, gave me the opportunity and privilege to speak over here, and I said to you, whatever whatever I knew about that, I have some idea about patents because I worked in a chemical industry for 2 years as manager research and development. And as I was working as R&D manager, it came to me, I got a patent from there, and I developed processes. Those processes, are still being used by the company. So the point is, I know a little bit of patent, and I have those two things spoken to me, and I know how patents are done, how patents are, because I have personally been involved in this kind of work in a chemical industry from the chemical perspective. The same thing happens with designs. The same thing happens with fabrics. The same thing happens with your drawings. The same thing happens with trademark. Earlier it was trademark. It was copyrights. From copyrights it is patent rights. So for books there are copyright. So there are many other things. For example, Rabindranath books. For 60 years the copyright was there. 1941 Rabindranath expired, and 2001 it was open. It became open, and everyone started publishing Rabindranath Rachanavali. I think you remember. Point is, that is how the patent also is having a certain period. That you will have that right. I think 20 years. Beyond that, again, the patent expires and it becomes a public property, and again people start working. But the real patent owner, they will definitely they will definitely make money out of it. So there was a telephone call again, another webinar. So someone is asking to join. So I have to leave. Thank you so much for giving me the opportunity opportunity of speaking to you. I do not know, I just speak from my own mind. So I told you whatever I just wanted to say. I'm grateful to Dr. Urmila Vakil and to all others for giving me the opportunity. Thank you very much, Dr. Joydeep Rishi, for your kind words in introduction. And thanks to all the teachers, my gratefulness to all the teachers of the Sarojini Naidu College. It is one of the very good with the West Bengal State University. And we pray that the college goes from strength to strength. The staff and the students will do better, because men may come and men may go, but I go on forever, as the Renaissance something like the issue knows. Point remains is institution, and unless we build an institution, we will not be remembered. The institution must be able to stand, and the institution must be able to keep. Yes, that's what I just would like to tell you. Thank you very much. Stay safe, take care, take all precautions for this SARS-CoV-2, and do the best as you can. In fact, already I hope that the college will continue to nourish, or we get control of all the persons who are there in the college. Thank you so much.
Thank you. Really. Thank you, sir, for your words towards me. We have actually heard, sir, I think for a number of times. I cannot keep count of that. But the number of times you have spoken, sir, it really is something amazing, and we learn something from you each time we hear from you. So thank you very much for your address.
Thank you.
It was really enlightening for us, and it really set the mood for this webinar.
Thank you, Doctor.
Thank you, sir. Before I go into the technical session, I have an announcement to make, and that is that some of the some problems with the YouTube streaming today. So there has been a link that has been sent to the YouTube chat box. So those who cannot follow there, you may please join in the Google Meet. So it is our humble request to bear with us and kindly join us here, so that you may actually be actually hear what our presenters have to say. Now, having said that, I would swiftly move on to the technical session. Actually, there will be two technical sessions. The first technical session will be by Dr. Sanjeev Chaudhary, who is the ex-Chief Scientific Officer of IPR and IR from IIT Kharagpur. And this session will be conducted by Dr. Shoma Aditya Bandyopadhyay. Associate Professor of Department of Zoology of our college. And this would be followed by a lecture by Dr. Aberi Dotto, Assistant Professor of our college. And the session will be conducted by Dr. Shonali Shaha, Associate Professor, Department of Physics. May I now invite Shoma to kindly take over? So Shoma, it's yours.
Thank you, Joydeep. Hello, everyone. Thank you for being here this afternoon. We are delighted to have with us Dr. Shonjeev Choudhury, our speaker for the first technical session. And he will be delivering a talk on role of IP system in academic institute with special reference to technology management. We will begin the session with a brief introduction of our speaker. Dr. Shonjeev Kumar Choudhury did his PhD in pharmacology from University of Calcutta. He has the distinction of rendering service both in academy and industry for long 50 years. He started his research career in Indian Institute of Chemical Biology, Kolkata. His areas of expertise include new drug discovery and development, technology management, and academy-industry collaboration. He was the head of Organon Research Center, a division of Organon International, the Netherlands, for about 20 years. He has served as Chief Scientific Officer, IPR and IR of IIT Kharagpur, and was instrumental in setting up the IP cell and IP policy of the institute. He also served as consultant to a leading firm engaged in rendering services in various areas of intellectual property management. Dr. Choudhury is Fellow of Institute of Chemists, India, and also a chartered chemist. With these words, I welcome you, Dr. Choudhury. Over to you, sir.
Good afternoon. Can you hear me?
Yes, sir.
Good afternoon, respected Honorable Vice Chancellor, Dr. Ukil, the Principal of Sarojini Naidu College, Dr. Chatterjee, the Coordinator of IAQC Sarojini Naidu College, and the faculty members of Sarojini Naidu College. It is my privilege to have this opportunity to share with you some of the information, knowledge, or the experiences I have had during my course of working with the IPR system in general, and also in the IPR system in research-based academic institutes, because IPR is intricately related to research, and IPR is intricately related to the academy and intricately related to the industry. So most of the information may be already known to some of you, but still it is a time to recapitulate those ideas or information which may help the young aspiring scientific personnel to practice and to acknowledge the importance of IP in academic scenarios. So I would like to present it. Let me share you. So this is the main topic which I will be discussing for the next half an hour of the role of IP systems in academic institutes, but not, although the topic says with special reference to technology management, but that may not be possible but it take management side, technology management side. But I will give you a brief overview of the genesis of intellectual property system and its importance in academic institutes. One thing we must remember that change is the one thing which is permanent and which is inevitable. In a progressive country, change is constant in every level and every aspect, is in economic, scientific, academic, etc. So you have to accept the change. Right? You can very well experience the change because of the COVID-19 situation. Now a new word has been coined, that new. So change is coming and we have to accept the change. And why I am talking about change in a regarding because the IT system is intricately associated with academic and industrial sector. It is IT system is a techno-legal item. It has got a scientific aspect and it has got a commercial aspect. What is technology? When a scientific idea is able to be commercialized, then we call it technology. And next slide. If I will be talking about the normal industrial scenario and the changes in we are facing in the industrial aspect. There is significant growth in the history of world economy. Particularly, just like at this moment, there is a little bit of downtrend because of the COVID situation. But pre-COVID scenario, there has been a tremendous growth in the world economy. And that we hope that the revival of the world economy post-COVID scenario, that change will be a significant change that we expect. Perceptual and changes in the living of the in our society, in all society, in all countries. And there is a trade liberation. Now there is a, we call about because one of the whole world is a one country. Because of all these factors affect or impact the business scenario or the commercial scenario, which in turn has got some relationship with the intellectual property. That and which are basically done with the help of that locally available natural resource and which are the low cost. It is not the factor for competitiveness in a new scenario. We have to go for new product and new process. That is the demand of the market. That you come up double than AI comparison to India, where the government is the main financier of the R&D investment. Although the government and the authorities in the scientific science and technology management are advocating the patent system in the academy, and that has started the result. So we have to have good R&D scenario to generate more petrol products. Therefore, a knowledge patent system is essential for understanding how best to protect the fruit of the research. And this is very important, and unfortunately in the academic institutions or in the but isn't, and the students are not a part of the patent system very much. Although for the last 5-10 years, there has been a great effort by the government of India to promote awareness by the on the patent system by type in of the science and technology, and that's a very welcome move. Very welcome move. Now let us talk about the property. Property is originated from proprietor. Proprietor is meaning one's own possession. Generally, it is immovable asset. The word property also conveys meaning of ownership. But when the word intellectual is placed before the property, the concept of ownership does not change, but mean changes to something intangible as a result of activity. To explain these words, dictionary gives examples of patent or copyright. As I have already mentioned, that intellectual property law or the patent law are region specific or the country specific. However, the patent system is to promote. Now let me talk about the intellectual property. There are intellectual property. There are two types of intellectual property. That industrial property, which is about you were mentioning about the product process and things like that, design, etc., and the copyright, which is the creation of the anything written on a book, song, photograph, all these things come under copyright. Here I can tell you that copyright is an industrial property is again divided into patents, industrial design, and It encourages invention because the money getting out of royalty of that product can be plowed back into the research. It induces influencer to disclosure instead of keeping it as a secret at the earliest opportunity, so that it is not nobody can it out, or there is a protection against theft of the knowledge generated out of the research and development. And if it is good patent system encourages development and commercialization of the invention, so anything or the patentee assigned to a commercial or industry or anybody for a particular time of royalty, so they are legal binding, and other nobody can use that product. And all of this invention the aspect of that particular area. The other industrial once that knowledge widely and practiced widely, then the academic freedom is promoted amongst the faculty members of the scientific staff. And it safeguards the interest of inventor that we have already discussed. It enhances the incentive for research, development, and discovery of new knowledge, because he knows that, or the inventor knows that his knowledge generated can get some money out of it if it is a commercially viable patent, and that can give him or her a financial incentive to plow back that money into research activities. To provide a system that keeps a balancing, what I am talking about, the balancing between the societal benefit as well as the inventor. Inventor gets some feedback in the terms of financial reward, and the society gets the new product or new patent against some legal safeguard from the engineers. But one thing is sure for the academic institute, that the students who are involved in the research, their interest or their involvement in the generation of the patentable subject matter, generation of we normally formulate or design a molecule, or and then we immediately go for a novelty search. And if the novelty search does not permit us, even if wholesome desired activity, we have to reject it. Because, so patent literature search should be one of the very important aspects and before formulation of a research project. And the other thing which is very important for every academy as well as the enterprise sector, that there is a low level of partnership. Unless there is a partnership between the academy and the enterprise sector, there would not be any progress in the patentable invention, because there is a mistrust. There is normally a mistrust between the academy and industry. Academic people normally think that the industry, enterprise people will be minting money by taking my ideas or by my product. And the industrial people, they go by the program and they go by timeline. So they say that in academy, there is a very slow program, slow research, so progress of research, so it will not maintain the timeline. There is insignificant number of patent-worthy research projects right now because of the fact that we do not go for the patent search, or we do not go for the market market. That is because of the lack of academic industry partnership with even some of the leading or pioneer scientists. They may not be aware of what is the need of the industry. So that's why, so patent-worthy research projects should be the priority if we go for a patentable product. Lack of culture of the patent filing. Normally, whenever we got a research work done, even without looking at whether there is any patentable material is there or not, we go for publication of the report. Because we know as a scientists always go for publicity, because that gives them some academic award, academic standing, that I have published so many papers in so many good journals. We do not give so much importance if somebody says that I have got one publication and 130 patents. This is the kind of cultural mindset that has to be addressed. So, but on the thing which I want to emphasize, that the IPR potential exists in academia, because the product comes from the novel scientific discovery, basic scientific research. Basic scientific research is the mother of the patentable product or process. And that is evident by the fact that the Nobel Prize is mostly owned by the people from the academy. There is very few Nobel Prize winners from the industry. But the new products or new process, particularly even in the drug sector and from the pharmaceutical side, that 90% of the drug is developed by the industry. Only 10% or 5% of the drug is developed by or came out from the academic research. So there has to be a marriage, there has to be a synergy between the academy and enterprise sector to have a patentable product. And there are some ethics also, there are some ethical aspects of the patentable patent system, rather, which I can tell you right now. That there one gentleman went for a surgery, and that surgery, the surgeon took out some of his, some part of his organ, and he kept it, and he afterwards handed over that organ to a commercial research organization, and they is a biotechnology company, and they found out that one of the genes of that from that tissue is HIV resistant. So, HIV, that gene can induce some protein which can kill the HIV virus. And they went for patenting of that variation. When that gentleman who was operated upon came to know that they have discovered a product by utilizing his tissue or his organ, they filed a case against them that I should get the patent of that product, not you. But the judge gave the verdict that when a part of your organ is excised from your body, thereafter you don't have any right on that tissue. So the patent was awarded to that company, not that gentleman whose tissue was donated, worked upon. There is a two aspect. One is the social aspect and one is an ethical aspect. That social aspect is that if you do not allow that company to market that product, then the society is deprived from the some useful product which is also came out from your tissue or from your body. But the social aspect is that the society is getting benefit out of that, so you should allow it. But the ethical aspect is that should it be done that what I own, because my own body part, I cannot own the outcome of that body part. So this is all about what I am to share with, but at the same time, I would like to talk to you about that the technology is dominated in our country. The technology or the management of the technology or the management of science and technology is dominated by two types of people. Those who understand what they do not manage, and those who manage what they do not understand. So this is a dichotomy. We prefer that earlier times, those who understand what they do not manage should be at the helm of the affairs of science and technology, so that the right thing or the right problem has to be addressed. But I like to conclude with a word from Mark Twain that a country without a patent office and a good patent law is just like a crab that cannot travel anyway, but sideways or backwards. Thank you very much.
Thank you, sir. Thank you so much for the informative, interesting, and engaging deliberation. We will quickly now move on to the question answer session. We have a few questions with us. Here is the first question. Sir, are you ready? May I ask the first question?
Yes, you can.
So the first question is, what measures Indian government has taken to protect and aware about IPR?
India, that I have told you that TIFAC is an agency of the Department of Science and Technology, which organizes organizes seminars, awareness program in every academic institute. They have got a branch in the Department of Science and Technology, Government of West Bengal. Am I connected or am I doing?
Yes, sir, you are audible.
Okay, so you can hear me.
Yes, sir, we can hear you.
Yes. Should I shut down my microphone now? Should I mute it? Hello?
No, sir. Please continue. Please
Can you
continue.
hear me?
Yeah, yeah.
Can you hear me?
Yes, sir.
Yeah, there is one lady called MS Home Chaudhary, who is in charge of that cell in Department of Science and Technology of Government of West Bengal. If you can approach them, or you can approach the Chief of Delhi, organize seminar or symposium awareness program. They have done some in but still you can always organize seminar, or you yourself can organize some seminar or workshop with your students and faculty members and invite some experts from the patent office in Calcutta or some of the people who are practicing patent systems, some of the people in the leading patent management firms in Calcutta. They are practical people. They practice the patent system. What is patentable, what is not patentable. Like living things cannot be patentable, but microorganism can be patentable. These are all the new things added into the new law. Previously, microorganism was also not patentable, but in the new law, microorganism has been allowed to be patentable. So there is a government is fully aware to promote patent system, and the CSIR has got a very strong IPR cell, which is also help in filing the patent. Even they, in fact, can give you a financial help for filing the patent through an undergraduate or postgraduate colleges, so that they get hence a monetary grant also for that kind of thing.
Okay, sir. Thank you, sir. Moving on to the next question. What are your views on the counter movement to IPR, where people are striving for free access of IP, as for example, Linux as a counter to MS?
Can you repeat it? I don't know.
Yeah, sure, sir. What are your views on the counter movement to IPR? What are your views on the counter movement to IPR, where people...
That's what Mark Twain already said. That they will either move sideways or backways. Unless there is an IPR, there will be no incentive of R&D. And unless there is an incentive for R&D, there will be no patentable subject matter. And unless there is no patent system, the scientific people or I know that there was one product in our Bengal that was mainly used for boils and wound. I do not, I'm forgetting that name. That was a beautiful formulation, but that formulation was passed from generation to generation. And that gentleman has no son. So unless he passed on that formulation to one of our daughter, and after the death of her daughter, that product is out of the market. That's called what we call the trade secret. The trade secret is one thing that the pitfall of the trade secret is that it is susceptible to theft by your own employees or by your competitors. But if you go for a patent, then nobody can get your idea without paying you. If they want to get it without your knowledge or without your permission, you can file a suit against, or you can file a case against him. He can be penalized, and there are lots of cases of that patent infringement what Chaudhary was talking about, which is a huge subject. That what is called patent infringement. That whenever we file a patent, suppose we file a patent for a molecule which is used as a drug for a particular disease. But while filing a patent, normally as a scientist, what I do, I go for all kinds of constituents and derivatives, whichever I can think about, to include in that patent literature so that nobody can go into that area without my permission or without taking assignment from my patent. So patent, because there was one gentleman, once I said that Nurul Hasan, who was the governor of West Bengal, he was in one seminar of the Bengal Chamber of Commerce. He was talking about that why it is a copyright. Why copyright? Because 13th grammar book on English is written by copying the first year copyright already published. So yeah, he is very much against that copyright. But copyright is now important because of the computer program. And although computer program is not patentable in India, but in abroad, you can go for PCT application for computer program, or computer program is India if it is a part of this where that system is operated through that software.
Okay, sir.
So
Thank you,
also, you know that India doesn't have a product patent till 2005. We are copying the process of the already known drugs up to 1995. And there are proponents of that India has made a great progress by copying the processes of the already patented molecule. So there is no need of product patent. But if we do not have, that was the idea, opposition while the product patent was introduced. But the proponent of the product patent was that unless you get a product patent, no new drug will come to India. No company will introduce any new drug in India because immediately it will be initiated by another competitor. So that's why the product patent is important. And WTO, World Trade Organization, made that PCT system and made it compulsory that India has to go for a product patent in the year 1995 and gave India 10 years time to transform from process patent regime to product patent regime, and 2005 is the final deadline, and from 2005 we are going for a product patent only. But product patent, even the new use of a known compound cannot be patented. These are all these tidbits that are of the patent system.
Okay, sir. Thank you so much. Thank you so much for answering all those questions. Now, without further delay, we move on to the next technical session, and I request Dr. Shonali Shaha to conduct the next session. Over to you, Shonali.
Thank you. Am I audible?
Yes.
Good afternoon to everyone. It is a great pleasure to introduce our next speaker, a young faculty of this college, Dr. Kaveri Dotto. Dr. Dotto completed her graduation with honors in zoology from Lady Bribon College, Kolkata, and masters on the same subject with specialization on cytogenetics from University of Kolkata in 2009. She pursued her PhD work on molecular cardiology from Calcutta University and was awarded the degree in 2017. During this tenure, she published 8 research papers in international journals. After that, she changed course and attained a postgraduate diploma in intellectual property rights and patents from Nalsar University, Hyderabad in 2018. Dr. Dotto is a registered patent agent with the Indian Patent Office and has worked as a patent professional in a private law firm in Kolkata for 1 year, where she gained experience in drafting and filing of patent applications, in doing patentability search and analysis, and in participating in infringement suits. In December 2019, Dr. Dotto joined this college as an assistant professor in the Department of Zoology. Today, she will share her views with us on scope and avenues of intellectual property. Now, I would like to request Dr. Dotto to deliver her presentation. Dr. Dotto, please.
Thank you so much, ma'am, for those kind words. Good afternoon, everyone. Let me take a moment to say how incredibly fortunate I am to be a part of this wonderful event. It is an honor and an absolute pleasure to be a speaker at this event, as well as represent Sarojini Naidu College for Women to you all. Now, our previous speaker, Dr. Sanjeev Chaudhury's talk was an absolute gem of information, as was our Honorable Vice Chancellor's keynote address. So it makes the job a little more challenging for me to do things differently and try to give you a little bit more information. So I'm going to try to do that. But first, let me set up my presentation. So give me a moment for that, please. Is my presentation visible? Can anybody confirm?
Yes.
Oh,
yes, it is.
Thank you so much. So,
yes, Kaveri.
Thank you. I'll go ahead then. So my topic today, as has been said, is scope and avenues of intellectual property. So what I am essentially going to be talking about are points that answer these questions. Like, what is the scope of intellectual property? And from all the different types of intellectual properties, what exactly are the forms of the rights that can be applicable to them? I will try to cover just the 3 main types of intellectual property rights, or IPR, among the 7 that there are in total. How can these rights be of actual benefit to you as a person or organization? And finally, I would like to talk about how you can go about getting these rights for yourselves, or are they naturally yours? So we'll try to look at all these aspects. So what is the scope of intellectual property? What are the things that are expressions of our intellect and can be called IP? So in the next slide, let's see if you can identify what are the IPs in the things that is going to be shown to you. Let's see that. Okay, so in all of these things, if you said yes to all of them, that they all have IPs in them, intellectual property expressions in them, then you are correct. Because all of these things that you see and use in your daily life all have some form of intellectual property associated with them. They are all protected also by a variety of different rights to ensure commercial gains or monetary profit, as Dr. Sanjeev Chaudhury was telling you about. And those rights and that profit is applicable to all those either individuals or companies that hold these rights. And on the other hand, what these rights do is prohibit or punish people who try to compete unfairly and infringe on these rights. So if we take the most basic items over here, which are, say, a food item and a drink item, that is the KFC and Coca-Cola, you might be asking me where the intellectual expression or what is the intellectual expression in, say, pieces of delicious chicken or, say, the sweet fizzy drink. I will tell you what they are. So the intellectual input in these two cases lies in the special recipe that makes KFC unique, and likewise for Coca-Cola in the formula for making it. So things like a secret recipe for a food item, a formula for a drink or chemical, say a plan of advertisement for a company, which is both unique and top secret, they form a type of intellectual property right known as trade secret, as Dr. Chaudhary was just mentioning a few minutes before. And these trade secrets are precious assets. So they are confidential information which by their secret nature give you or the particular company a competitive and commercial advantage over other such businesses. So the next time if you have, like, say, your grandmother's recipe for the best chutney in the world or the best mutton curry, guard it well, because you might one day want to turn it into a business, and that trade secret is going to help you get a commercial advantage. And after that, the idea of having IP expression here is not over. The next comes the iconic logos of KFC and Coca-Cola. So these three letters of KFC and that cursive writing of Coca-Cola is, you can say that they are the faces, so to speak, of these companies or brands, and they make up the most visible and valuable part of intellectual property rights, that is the trademark. Then, even after this, there is also another form of intellectual property over here. It lies in the shape of the Coca-Cola bottle. So, have you ever wondered why Coca-Cola has never really changed the way its bottle is designed very much over the years? That is because this particular type of shape is also iconic and a part of its brand value. So whenever you see a bottle of this shape, even if there is no logo, you know instinctively, right, that it is Coca-Cola. So this particular form of IP is particularly known as, or this forms a part of an IPR that is known as trade dress, particularly in the US, and in India, this is a part of the trademark regime. So you can see that the finger licking good chicken and your good times Coca-Cola are actually protected by a variety of different but related intellectual property rights. So now if we take a further closer look at trademark and the related rights, we will see that a lot of different types of things can be protected by this sort of IPR. So let's see what these are. So say you have a business, or say you're trying to start up a business or a company which provides services to customers or clients. Like, say you have Google, which helps in searching. You have Facebook, which helps in connecting and socializing. Then these sort of services can be protected by service marks, which is also a form of trademark. So you have a brand which provides a service, and you want to increase the brand value, and you want to encash on that brand value, you go for a service mark. Then also you have something else. So if you have a body or organization or a company which provides certification of goods, you are an authority in that, or you provide certification for goods, services, processes, etc., your particular brand of authority can also be protected by a type of IPR, which is known as a certification mark. The examples over here can be, say, the ISI mark or the wool mark. So these types of marks determine bodies which are authorities for qualities of goods and, say, wool. So no other body of authority can certify for ISI or Woolmark for products to claim them as authentic. So that increases the value of the body of authority. So the certification marks helps in increasing their value. Now, again, if you have a certain sort of organization, like say the Rotary International, which does a type of work, a set type of work, then their brand value of such organizations can also be protected under what is known as a collective mark, which is also falling under the purview of trademark. So you can see that trademark and its related types of RPRs can cover a vast number of different types of things. So the next time, say, you experiment in the kitchen and come up with a new type of sauce, don't tell anybody about that recipe. First and foremost, keep it a secret. So that will form your trade secret while you try to come up with ways to put up your homemade sauce business. Because in time, you never know, you may become the next, say, Kisan, the next Maggie, the next Ching's secret. And that trademark and trade secret will earn your brand value and lots of money. So the idea is that you have this particular sort of intellectual expression, not just for scientific inventions, but for everything else. And that is going to help you give certain monetary benefit in return for doing that product, giving that service, right? So before going into the trademark steps, I will just try to give you what is the formal definition of a trademark, or rather, what can be considered as a trademark. Then a trademark can be a word, it could be a phrase, a fanciful phrase, say Gucci. It could be a word, say Apple. It could be a symbol like you have seen, or it could be any sort of design that will identify and distinguish the source of your own goods from those of any others, right? So when you know that, then you will be able to design a trademark for yourself, for your own business, for your own purposes. Now then comes the steps to take for a trademark. So what is the first step? The first step is always to do a trademark search. Because say if we go back to that sauce that you had made, that very special secret sauce that you had made, and you name it hot and sweet, and then you try to register that as your trademark at the trademark office. Unfortunately, it will be quite likely that the application will be rejected. Why? Because Maggie already has a trademark for hot and sweet. So it is always better to find out whether your logo, the name that you have said, or the shape is really unique or not before progressing further. So once that part is cleared up through a trademark search, then you can get an application, a trademark application drafted and filed with the trademark office. The trademark office will then examine your application and respond to you in one of three ways generally. So either they will find everything in order and proceed to grant you that trademark, or they will ask for additional information and clarification, or they might reject your trademark on certain grounds that are there in the Trademark Act. Now, if you have the trademark granted, then the matter doesn't end there. You will have a party and celebration, obviously. But what you need to do is every 10 years, you need to pay a renewal fee to keep your trademark live. Because otherwise, your right will lapse, and then your precious brand logo will be able to be used by anybody without any consequences. So if that happens, what is going to happen is you have built up your brand, you have built up your value. That particular sauce that you're trying to sell is the best in the business and everything. But suddenly somebody who, because you had forgotten to renew your trademark, somebody else cashes in on your brand and sells a different sort of sauce, and your sales go down, your profits go down, and your brand value and goodwill is lost. So that is why, if after the grant of a trademark, it's important to remember that all of these rights are not, for forever. They are very time bound, and for trademarks, you need to keep renewing it, right? So this is one sort of IPR that we have talked about. Let's go on to the next sort of intellectual property right. Now, that is the patent. Now, I will try and keep this very, very short because Dr. Chaudhary, as well as our Honorable VC, has talked extensively and exhaustively about the patent system, the patenting system, and everything. So I'll just try and keep it very short. So, as they have both said that this is an intellectual property right, it is the most profitable type of intellectual property right, but it is also the hardest to get. Now, as Dr. Shonjib Chaudhary has been saying, that this is a negative monopoly. Now, what that means really is that when you get a patent for any sort of invention or innovation, it actually, what it does is it prohibits the making, selling, using, importing, licensing, exporting, all these sorts of activities. It prohibits others from doing it. A patent will not actually compel you to make or sell or use or import these things. But what it will do is it will prohibit others to do it. So indirectly, it gives you a monopoly on all of these things for a finite period of time, that is 20 years. Now, this 20 years is important to know because that 20 years is counted from the date at which you first file your patent application at the patent office, and not the date from which you had originally invented your invention, or the date from which you get your patent granted. Now, why this is important? This is important because from the time when you first file a patent application to the time when you actually get a patent application granted, there can be a delay of, say, a few months to a few years. So the current convention and the current law is that the 20 years is counted starting from when you had first filed, and not from the date when you have actually gotten a grant for that patent. Now, with regards to filing, what I can say one more thing is that Dr. Chaudhary has been saying that patents are territorial rights. That means you have an invention, you file a patent for that in India and you get it granted. Your patent rights or your monopoly is existent only in India, but say not in the US. What Patent Cooperation Treaty does, or the PCT route of patent application does, is it allows you to file a patent, one single patent application for all the different countries that you want your right to be protected in, that you want to get a patent in simultaneously, without having to, go to every country and file it separately. So this is like a one application, one international application for more than 150 countries. Now, why this is important or why this is needed actually? Say you have an invention for an air conditioner. So air conditioners, you have to also know that air conditioners will be most profitable, your market will be most profitable in countries which are very hot. Say, for example, India, Sri Lanka, Singapore, Malaysia, and all these places. So what you will want is to actually exploit that market and have your patented technology work over there, so that those markets make you some money. So Patent Cooperation Treaty will actually help you to apply in all of these countries simultaneously and not just in India. But then again, it also gives you the opportunity of applying to only these countries, say the Southeast Asian countries, and not in the US. But if you wanted to, you could also do it in the US. So it gives you a little bit of flexibility. Okay. But before you go all out and start filing these applications, like Dr. Chaudhary had said, you need to know what exactly is an invention in the eyes of the patent law. He has been talking about it. So an invention is, in the eyes of the patent law, is a product or a process which has to satisfy three criteria. It has to be novel, it has to have an inventive step, and it has to be useful or have an industrial applicability. So once you satisfy these criteria, then you can go towards the steps of patenting. Those steps will be just like you had seen for trademarks. First and foremost over here, again, a search has to be made for patentability. A prior art search has to be made for patentability. So what is this actually? Just a second. So prior art search is trying to find out whether there is any sort of mention about your type of invention, something similar to that, or exactly the same sort of invention that you have in any sort of communication in the world prior to the date at which you want to file your application to the patent office. Say you want to file your application to the patent office on the 1st of January of any year. Prior art search would be searching for searching for innovations and inventions that are either the same as your invention or very close to it. How much closer that you can get up to, say, 31st of December of the previous year. Why this is important? This is important because that will determine whether your invention is truly novel or not. And that is the first and most important criteria that has to be satisfied before you can take your invention and start filing for it. Okay, so once that is established, you should go for a drafting of patent application by and I could be biased because I am a patent agent, but it's better to have a professional draft your application for you because it is a somewhat complicated process. Dr. Chaudhary has been saying that there is a need for putting out a proper specification of application, and our VC sir has been saying that patents patent literature is generally very sketchy. That is not really the case. What we as patent agents, or what a patent application, a drafting of a patent application means, is trying to secure the broadest possible protection for your invention, but also fully disclosing all the nitty-gritties and specifications of it. So that is why a patent professional is generally required for drafting it, and then that patent application can be filed. Then, just like as was the case for the trademark, the patent office will examine your application and respond, just like the case was in case of trademark. Here, however, if you are granted a patent, you need to renew it every year instead of every 10 years. Also, after the period of 20 years is over, you can generally no longer claim the patent monopoly and invention, and your particular invention comes into the public domain. So patent is very specifically a time-bound intellectual property right, and that also increases its value, right? So that's all that I wanted to really talk about the patenting system. So I'll go on to the last prevalent form of IPR, that is for creative and artistic expressions of intellect, that is the copyright. So what's a copyright? These are rights that creators have over their original literary and artistic works. So what sort of works can generally be protected by a copyright? Do we know all of them? Let's see. So these all works can be protected by copyright. The first of them is a literary work. And in this case, I should also mention that computer programs and databases are considered as literary works, which are naturally protected by copyrights, as opposed to patents, if you had ever wondered, that is. So computer programs are generally protected by copyrights, and they are not generally patentable, except for certain exceptional circumstances. Then you can have works of music, works of drama, pantomimes, choreographic works, dances, pictures, graphic arts, sculptures, architectural works, as well as cinema, motion picture, and audiovisual works. So now I wanted to share something with you over here. So why do I have Barack Obama here? That's because there was an interesting copyright battle over his picture. So the street artist, Shepard Fairey, had produced the graphic Hope poster, which was very popular in the presidential campaign, from a picture taken by the journalist Manny Garcia. So you can see the Hope poster on the left and the original picture taken by Manny Garcia on the right. And Manny Garcia was working for Associated Press at that time. So the Associated Press then brought a copyright infringement suit over the artist, for using that picture as a source of the poster without taking permission from AP. And they also were saying that the copyright to the whole poster itself should also then belong to the Associated Press. Now, before the court could really get involved into it, the two parties came to a private settlement. But it goes to show that we have to know the rules and regulations of copyright if we create a work of art ourselves or decide to use someone else's work, so that we may avoid unwanted troubles on one hand and also are not cheated out of our share of commercial profit on the other. This is also very important because if I am not wrong, a lot of us here are academics and we have been thrust into online teaching over here. So our classrooms have been flipped. And if you're doing online teaching, we have this habit of copying things from the internet and taking everything from the internet and going with it. So it's very important right now to understand two things, copyright and plagiarism. I'll come to that in a little later. So as a creator, what rights will you be having? Let's look at them. You will have the right to copy or reproduce your work. You can publish it in any way you want to. You can perform it in front of any audience that you want to. You can communicate it to the public. You can make a film or sound recording out of it. You can translate it, adapt it, and for monetary benefit, you can sell it, license it, rent it, however you please, right? Also, you have to keep in mind that there is a time frame for creating the work of art, which means that you have particular durations of copyright, right? So on the table in the right side, you can see different sorts of works of art have different time frames of copyright. So if you have a photo or applied art, that copyright will exist 25 years from the creation or taking of that photo. For cinema and audiovisual work, it is 60 years from the date of release of that film, or 60 years from the date of creation of the film, if the film does not get a public release. For any sort of anonymous and pseudonymous work, it is 60 years from when that particular work has been made public. And for all the other kinds, everything else, it is the copyright exists for the lifetime of the author and 60 years plus from the year after which the author dies. Now, one more thing I have to mention over here is that at the time of creating any sort of work of art over which you would like to have a copyright, suppose you were employed somewhere, then there might be a problem with determining who holds the copyright, because if you're employed at some place, then generally whatever work of art that you create over there, the copyright belongs to your employer unless you make an agreement with your employer stating otherwise, right? So that should be kept in mind. So that's more or less that I wanted to say in a nutshell about copyrights. But one more thing I wanted to talk about, which is something especially relevant to all of us, but it can also be very confusing. It is the matter of plagiarism. So, is violating a copyright the same as plagiarism? They're actually not. They are related acts, but they are also distinct. So, a copyright infringement or a copyright violation includes the unauthorized or unlicensed copying of any sort of work which is subject to copyright. What does that really mean? It means that if you have an idea, that idea cannot be protected by copyright. But if you have a fixed expression of that idea, which means if you have Harry Potter as an idea in your head, that is not protected by copyright, or that is not even protected by hearsay. You relate that idea to somebody else, they can use it. But if you have Harry Potter in the form of a book, that book is under copyright. Okay. And then if you have plagiarism, what is plagiarism? Plagiarism is actually using someone else's work or ideas without giving proper credit. So let me give you some scenario examples to better explain this. You can have three different types of scenarios in the present context. So in the first case, you can have plagiarism without copyright violation. So if you have, say, Shakespeare's works, his dramatic works or his sonnets, and if you copy from them, put your own name to it, and then post it on a website, as a part of an article, then you would be guilty of plagiarism because you did not give due credit to Shakespeare. But you will not be guilty of copyright infringement because Shakespeare's works are in the public domain. And why they are in the public domain? Because the period of time, the lifetime of Shakespeare and then 60 years has already been over for a number of years now. So his works are in the public domain. So you will not infringe the copyright, but you will be plagiarizing. Then the next scenario, say you copy the lyrics of a recent hit song and post it to a website with credit to the singer or artist. So since you've given credit to the artist, you're not plagiarizing. But since this is a recent top song and you have copied the lyrics, you will be infringing the copyright because you have not asked for permission from the songwriter or artist whether you can copy those lyrics, right? And the last one can be both a copyright violation and plagiarism. So if you copy the lyrics, you are already violating the copyright, and then you don't even give credit to the particular singer or artist and claim that those lyrics were yours, then you're also plagiarizing the songwriter. So every time you copy something from the internet, are you really always violating copyright? This is the next question, right? But actually, no. All copyright laws give you certain exemptions, which is known as fair use. Let's see what that is. Fair use is actually an allowance which is made for certain purposes, such as criticism, commenting, reporting in news, teaching and education purposes, scholarship and research purposes. So if you use somebody's copyrighted material, but explicitly for these mentioned purposes, then you will not be infringing the copyright of that work, right? So we are all in creative mode right now in the lockdown situation. So the next time any of you makes an original guitar tune and you put it up in the YouTube, make sure to go for the copyright statement or a copyright logo so that nobody else can take it, make hit music out of it without giving you credit or monetary compensation. Or if, on the other hand, you use somebody else's work, make sure that you are generally using it for the clauses of fair use, or otherwise you can always get a license or permission from the person, right? So with that, I come to the end of my presentation. I hope you all became a little better informed about the three main types of IPR. So the next time you have that particular source in mind or the book in mind, you know what to do, okay? So I would like to just take one last minute to acknowledge and thank the following people for being so very helpful and encouraging towards me. Our Honorable Vice Chancellor, West Bengal State University, our beloved principal, all members of IQAC, the former and current heads of my own department, Department of Zoology, all my other colleagues at Sarojini Naidu College for Women, especially Tomogno Roy, who's been our technical help since day one, and also my fellow participants. All of you, thank you so much for your patient hearing.
Can you hear me?
Yes.
Can you hear me?
Yes.
Very well said. I am proud of you.
Thank you so much, ma'am. Thank you so very much.
Very well said. Very well said. Thank you. I am very proud of you.
Thank you so much, ma'am. Thank you so very much.
Thank you, Kaveri, for your very lucid and informative session. You have covered so many things with very simple examples. Thank you very much. So now we'll go to question and answer session. Here is one question. What is the scope of IPR strategy in pharmaceuticals industry of India in this COVID situation, particularly in case of the vaccine?
Particularly in case of the last one?
The vaccine.
The vaccine. Okay, so India has an interesting stand when it comes to pharmaceuticals. So India, on one hand, encourages the patenting and commercializing of drugs and pharmaceuticals, but on the other hand, there is a clause in the patent law which says that if you have life-saving drugs, then generally they are to be supplied to the general public at a reasonable rate. So patenting in that case becomes a problem. A. Second thing is certain conditions are there or certain exceptions are there in our patent law. Like you have, if you have a particular chemical or a compound which just shows a new use, the compound was already previously known and you just have a new use. Say for the COVID situation, you've discovered a new use for it and you're using it for the for maintenance of COVID, then those sorts of compounds are not patentable. As far as coming to vaccines, generally living organisms or methods of treatment, vaccine will definitely come under method of treatment. You cannot really say it's a COVID vaccine and it will not be a method of treatment. Unfortunately, methods of treatment are not patentable by Indian patent law. So what do we do then? So I mean, you spend a lot of R&D research money, funds, and you come up with a proper COVID vaccine and you cannot get it patented, which means that you will not get any monetary benefit from your particular idea. What it requires is something which our Honorable Vice Chancellor was saying, a sketchy patent application, which means that your patent application has to be written in a manner which will expose or will give a full disclosure of what your vaccine is about without trying to claim that it is a method of treatment. So in this case, most definitely it should be taken up as a product patent instead of as a process patent, because once you say it's a process, it will be a method of treatment and it will be voided. So if you can make it as a product patent with some very cleverly used patent language in the claims and specification, then there are high chances that your patent can be granted and you can have a patent for your COVID vaccine. On the flip side, though, if you have a vaccine which is patented, it is going to drive the value, that is the price of the vaccine, very high, because you're going to try to be exploiting it commercially and getting benefit out of it. So I think a little bit of a balance is needed, where you can have that vaccine but you can also license it to pharmaceuticals and make money that way through royalty, without those pharmaceuticals trying to drive up the price of that particular vaccine.
Thank you, Kaveri. The next question. Is the patent law in India adequate for generating research interest?
Yes, as of now, the patent law in India is, I would say, if I were to be very conservative, I would say it is adequate, but I would say it is a little restrictive, because we have around 17 sorts of exceptions which have to be taken into mind while doing patenting. So like I said, you cannot have a method of treatment as a patent. You cannot have living organisms as patents. You cannot patent them except for microorganisms. You cannot have previously known chemicals as patents if they do not show a particular exceptional inventive step, etc. So you have a lot of restrictions in that manner which are not there. And also, say, computer programs are not patentable in India, which is a very, very big market right now. So I would say it is a little restrictive. We have a lot of curbs on what can be patented and what cannot be patented, which is not there, particularly in the US patenting scenario. They can patent almost anything under the sun. The European patent scenario is kind of in between. They have certain restrictions and they have certain liberations as well. So yes, we can work towards more generalizations and lifting some of the curbs, but for now, I think it's pretty okay.
Now, last question. Is PCT needed for COVID vaccine to be used in India if it is invented outside India?
Yes, see, there are two parts to these questions, or there are two ways this can be said. If you have a vaccine which is invented outside India and that vaccine gets patented outside India, then there are two ways you can approach this. The government of our country can have some understanding with the government of the inventor country, and then get it to us at say reasonable rates, which should be what should be done because it is a life-saving drug at this moment. But if you're talking about commerce, then yes, if it is patented outside India, then if they want to exploit, whatever inventor wants to exploit our country's market, and they will definitely want to exploit it because we have the highest numbers of COVID cases here. So if they want to exploit our market, then definitely they will want to have a patent in India. And for that case, definitely going the PCT route is the best and easiest policy. There is really no point in having patents say in the US or in the UK where they are basically vying for the rights to patenting really and developing the vaccine. There is no point in going to separate countries. You will definitely want to go to the PCT route. That gives you the best flexibility.
Thank you, Dr. Ege, for your very lucid and clear explanation. Now I would like to hand over to Dr. Jaidev Rishi to continue the next part.
Thank you, Shonali, and we had an excellent technical session. Firstly, there was a very informative lecture from Dr. Sanjeev Kumar Choudhury, and which was aptly followed by Kaveri, and she had a very lucid and excellent presentation as well. And I would also take the opportunity to thank Shoma and Shonali for their excellent cooperation in this matter. On the behalf of the organizers, I would say sorry for the technical glitches that we had today, but you understand that these are beyond our control. So please bear with us tomorrow as well. And tomorrow we hope to have another 2 very engrossing technical sessions on research publications. And we would have Dr. Shondeep Poddar, the Senior Research Director, Lincoln University College from Malaysia. He had been with us for the entire day. And Dr. Priyank Praveen Patel, Assistant Professor, Department of Geography from Presidency University. So they will be there and they will be having their presentation. So we hope to meet you tomorrow at 2:30 again. So, and many of you, some of you have actually asked for feedback forms. Your feedback forms would be provided at the end of the webinar. So tomorrow, so please wait till that, and we also expect you to join tomorrow, so so that you can actually make our effort a success. And we would also be providing the links for the next day's webinar in our website, in our WhatsApp group, as well as they will be mailed individually to you for the next day. So that links will also be provided by tonight. So thank you for joining us. And now I would be requesting Dr. Shukanna Sarkar, Associate Professor, Department of History, for the final formal vote of thanks.
Can you see me? Can you hear me?
We can hear you, but we cannot see you.
Cannot see me. Can you see me now? The microphone.
We can see your picture, but we cannot see you live.
Okay, that will do. Good afternoon to all of you. It's my privilege to propose the vote of thanks on behalf of this esteemed institution. At first, I want to express our gratitude to Honorable Vice Chancellor, West Bengal State University, Professor Dr. Bashok Choudhury, who despite his busy schedule has spared his precious time for us, graced this webinar with his presence and delivered keynote address. Thank you, sir. for your valuable thoughts on scope of researches, intellectual exercise, patent rights, and infringement. And thank you for sharing your own personal experience regarding patent-related issues. I extend our sincere thanks to Dr. Sanjeev Kumar Chaudhuri, ex-Chief Scientific Officer, IPR and IR, IIT Kharagpur, a stalwart in the world of science, for sharing his immense experience, wisdom, and valuable insights regarding IPR potential exist in academia. Thank you, sir. Because of you, this webinar has really touched the height that was aimed at when this program was initially envisaged. Our warm and heartfelt thanks to Dr. Kaberi Dotto, Assistant Professor, Department of Zoology, Sarojini Naidu College for Women. She has made us proud with her profound knowledge, expertise, and skill reflected in her wonderful presentation, which is informative as well as enjoyable. I extend our sincere thanks to Dr. Urmila Ukil, our principal madam, for delivering the welcome address and for her vision, commitment to work, and for being our backbone in our endeavor and constantly motivating and inspiring us. Thank you, madam. Behind every successful program of our college under the banner of IQAC, the initiative lies with our IQAC coordinator, Professor Dr. Sudeshna Chatterjee. I would like to take a moment to acknowledge the teamwork of our faculty under her guidance. Without the contribution of Professor Tomogno Roy, Computer Science Department, this webinar would have not only been difficult, but impossible also. So this acknowledgement would be incomplete without expressing our gratitude towards him. Thank you all for being participants in this event and for your kind cooperation. Thank you.